Imagine for a second that your family has lived on the exact same piece of land for, I don't know, 300 years.
Wow, that's a long time.
Right. I mean, you know every single rock. You
Yeah.
know the soil. You know exactly which tree gives the best shade on a really hot afternoon.
Your whole life is basically tied to that dirt.
Exactly.
Yeah.
Your grandparents are buried there.
Yeah.
Your entire identity is tethered to those exact coordinates. But then one morning, this guy in a crisp suit just shows up.
Never a good sign.
Never. And he's holding this single stamped piece of paper from some municipal office you've never even been to. And suddenly, just by the sheer force of the law written on that one piece of paper, you are legally trespassing on your own life.
It's terrifying.
It really is. You're forced to pack whatever you can carry and just leave the only home you ever know.
And the crazy thing is that's a very real scenario. I mean, it's the historical and sometimes modern reality for so many communities when property transfer laws are weaponized against them.
Right.
That concept, the idea of losing your land, of it being legally severed from you, is what the legal system calls alienation.
And that is exactly where we're heading today. Welcome to this deep dive. Today, we are wading right into the really high stakes, kind of murky and honestly ruthless waters of land alienation.
That's a heavy topic.
It is. We're going to look at the immense legal armor that's been built over decades and sometimes centuries to stop that exact nightmare scenario I just described from happening to the most vulnerable people in India.
Yeah, the protections are fascinating.
They really are. And we're using Osmania University's LLB 3-year degree subject as our guide today, specifically Unit V. So today we are acting as your personal law professors.
Grab a notebook.
Exactly.
Yeah.
But look, even if you are not sitting in a law school lecture hall right now, you really need to hear this. Because understanding these laws is basically understanding the blueprint of how power and poverty and survival actually operate in a modern state.
What's really fascinating here is that land law in this context isn't just about property rights, not in the standard capitalist sense anyway.
Right, it's much deeper than that.
It's an active battleground. You've got these massive historical injustices just colliding with really aggressive state intervention, and it's all happening while the economy is trying to modernize at lightning speed.
So how are we breaking this down for the listener?
Well, we'll trace it systematically. First, we have to understand the basic physics of how land actually moves from one person to another.
The baseline rules.
Right. Then we'll explore the extreme measures the government uses to lock down land that's given to the poor. After that, we dive into the really intense, blood-soaked history of tribal land protections.
That part is wild.
It really is. And finally, we'll examine the modern high-speed tribunals where all these desperate disputes actually get fought out today.
Okay, let's unpack this. Let's start with those baseline physics, the anatomy of the transaction, right? Because normally when we buy something, it's pretty frictionless.
Like buying coffee.
Exactly. Hand you $5, you hand me a coffee. Boom. The coffee is mine. But land doesn't work like that at all. So what does it actually mean to alienate a piece of land legally?
I know, alienation sounds like a sci-fi concept, or maybe like going to couples therapy.
Yeah, emotional alienation.
Right, but in property law, it's totally foundational. It just means the transfer of ownership or the transfer of specific rights in immovable property from one party to another. It's the legal mechanism of letting go.
Okay, so it's not just selling it then. It's more of an umbrella term.
Exactly. I mean, a sale is absolute alienation. You hand over the cash and you permanently transfer the title. Done.
Right.
But alienation also covers a lease where you're transferring the right to just use the land for a set time, or a mortgage.
Wait, a mortgage is alienation?
Yeah, because you're transferring an interest in the property as security for a loan. It also includes gifting the land, exchanging it, or partitioning a big family estate. Anytime a right tied to that dirt moves from person A to person B, that's alienation.
Got it. And because land is finite, and usually the most valuable thing anyone will ever own in the state, doesn't just let you do this casually.
Oh, not at all.
There is this incredibly strict framework, right? And it dates way back to British India. According to the notes, we're looking at the Transfer Property Act of 1882 and the Registration Act of 1908.
Yeah, those are the twin pillars. The Transfer Property Act of 1882 is the central law. It dictates the general rules of how you move property.
Like who can sell what?
Exactly. What can be transferred, who is legally competent to do it, and what the buyer and seller owe each other. But the actual engine that makes that transfer visible to the government, that's the Registration Act of 1908.
Okay, so I want to visualize this. Because if I own a plot of land and I agree to sell it to my neighbor, and he literally brings me a duffel bag full of cash.
A very heavy duffel bag.
Right. Why can't we just shake on it or, I don't know, write it down on a napkin. Is alienation essentially like passing a baton in a relay race? But you need a referee to physically stamp a certificate every single time the baton changes hands.
That's a great way to put it. And yes, you absolutely need the referee.
But why? Why the massive bureaucratic machine from 1908 just to validate what two consenting adults agreed to?
Because a handshake creates a localized memory, and memories fade or they get distorted or they literally die with the people who made them.
Okay, fair.
Let's play out your handshake scenario. You sell your land for cash, no paperwork. 10 years go by and you pass away.
R.I.P. to me.
Exactly. So your kids inherit your estate. They look at the land, they see the neighbor farming it, and they say, wait a minute, our dad owned this. Where's the proof he sold it?
And the neighbor just says, hey, we shook on it.
Right. So your kids take him to court. How is a judge supposed to decide that? It's purely one person's word against another's. Now imagine that scenario happening across millions of acres, generation after generation.
Oh, wow. Yeah, it would be absolute chaos.
Total unmitigated chaos. Titles would mean absolutely nothing.
Which brings us back to the Registration Act.
Exactly. The 1908 Act exists to create an immutable public chronological ledger of who owns what. It legally mandates that documents transferring immovable property like sales deeds, long leases, mortgages, they have to be formally registered with a designated government officer.
So it's about creating a public record.
Yes, public notice. If someone wants to buy that land 20 years from now, they can go to the registry, pull the history, and know for a fact that the seller actually has the right to sell it, and that there isn't some secret mortgage hiding on it.
And from what I'm seeing in the sources, the courts do not mess around with this requirement. They're completely unforgiving.
Very unforgiving.
Let's look at the case law. There's a big Supreme Court case from 2006, Satish Kumar versus Surinder Kumar.
That case is the perfect example of how ironclad this is. In Satish Kumar, they were dealing with an unregistered agreement. And the Supreme Court basically laid down an unequivocal rule.
Which is?
A transaction of immovable property has to be evidenced by a registered deed to be legally valid. Period.
So wait, if you skip the registration office, even if you handed over the duffel bag of cash, the sale just doesn't exist.
In the eyes of the law, it is void. It is totally incapable of conferring title.
That's brutal.
It is, but the court's rationale is that without registration, you can't even admit the document as evidence in court. You literally cannot use it to prove you own the land.
Wow. And there's an older case too, right, from the Andhra Pradesh High Court. Varaya versus Subbarao from 1964, it hammers home the exact same thing.
Yeah, it really emphasizes strict compliance, and not just with the registration part, but with paying the stamp duty.
Right, the state wants its cut.
Always. The state demands its tax, and it demands the formal paper trail, because that paper trail is the only thing stopping endless civil lawsuits.
Okay, but relying on dusty paper ledgers bound in leather from 1908, I mean, that seems incredibly fragile today. Pages get torn out, buildings catch fire.
Or get eaten by termites.
Exactly. How is a rapidly modernizing state like Telangana handling this verification process now? They can't still be using just ink and paper.
They aren't. They're actually actively overhauling it. Telangana has embarked on this massive digitization of land records.
Okay, that makes sense.
It's a huge shift. When you digitize it, you move from a vulnerable physical ledger to a highly secure, centralized database. It drastically reduces localized fraud.
Because you can't just bribe a guy to rip a page out anymore.
Precisely. Historically, if you paid off a local record keeper to lose a specific page, you could literally alter a title. Digitization creates a permanent, auditable digital trail.
And tied right into this modernization is the Telangana Rights in Land and Patadar Passbooks Act of 1971.
Yes. The Patadar Passbook is such an ingenious concept.
It sounds like a passport.
That's exactly what it is. It's an authoritative, state-verified passport for your property. They issue it to the landowner, and it contains all the vital details.
Like what kind of details?
Survey numbers, the exact extent of the land, taxes paid, any loans against it. So when a farmer goes to a bank for a loan or wants to legally alienate part of the land, this passbook is the definitive proof of their rights.
So it just streamlines the whole thing.
It completely removes the ambiguity of ownership.
And the state isn't just tracking who owns the land, right? They're also heavily restricting what you can actually do with it once you get it. The Telangana Agricultural Land Conversion Act of 2006 is a great example of this.
Right. That act shows the state acting like a macro-level urban planner.
because food security is a real issue.
Exactly. You can't just go buy 50 acres of super fertile multi-crop farmland and arbitrarily decide, hey, I'm going to pave this over and build a giant shopping mall.
Even if you own it.
Even if you own it. The 2006 Act imposes really strict regulations and massive conversion fees. You have to prove to the government that converting this land serves a much greater developmental purpose and that it won't wreck the local agricultural ecosystem.
Okay, so we've got the baseline mechanics down. We know how alienation conceptually works. We know about the deeds, the stamp duty, the digital passbook.
The rules of the game.
Right. But now we need to pivot, because we're leaving the realm of standard property transactions and entering this highly specialized, deeply protective legal fortress.
This is where it gets intense.
Really intense. What happens when the state decides that a specific piece of land absolutely cannot be transferred? Like, no matter how much paperwork you fill out or how much money is in that duffel bag.
We are crossing the border from traditional property law right into agrarian reform and social justice.
And that brings us to a huge piece of legislation. The Telangana Assigned Lands Prohibition of Transfers Act of 1977.
Originally passed in Andhra Pradesh and adapted for Telangana in 2016.
Let's start with the absolute basics here. What exactly is an assigned land?
Well, to understand assigned lands, you really have to understand the systemic inequality of the rural landscape. You have millions of people laboring on land they don't own, trapped in generational poverty.
Right.
To fight this, the government identifies tracts of state-owned land or land they acquired from wealthy landlords under ceiling laws, and they actively grant it to the poorest citizens.
They just give it to them.
Yes, they assign it to them for cultivation or just to build a small house so they have shelter. These are assigned lands.
But the law doesn't just use vague, generic terms like the poor. It is brutally specific about who gets this land. Section 2, Clause 3 of the Act gives a strict mathematical definition of a landless poor person.
And it is a critical definition. A landless poor person is someone who has absolutely no other means of livelihood outside of agriculture.
Okay.
And mathematically, they own a total extent of land that is not more than 2.5 acres of wetland or 5 acres of dry land.
Okay, I want to pause right here and dig into this, because here's where it gets really interesting. Why the distinction between wet and dry dirt?
It's all about the economics.
Right. What does that mean for the listener who is just trying to understand agricultural economics? Why exactly 2.5 acres of one, but double that amount for the other?
It's a brilliant reflection of ground realities. In farming, just having acreage doesn't equal wealth. Productive capacity equals wealth.
Okay, explain that.
Wet land is land that enjoys assured irrigation. It's connected to a state canal or a perennial river or a really reliable bore well. Because the farmer controls the water supply, they can cultivate 2, sometimes even 3 crops a year.
Wow, 3 crops.
Yeah. The yields are massive, and the risk of crop failure is incredibly low.
So it's high output, low risk dirt.
Precisely. Dry land, on the other hand, is entirely at the mercy of the monsoon. It relies solely on rainfall.
Which is unpredictable.
Highly unpredictable. If the monsoon is delayed by just a month, or if it rains too much in a single week and washes all the seeds away, your entire year's income is destroyed.
That's terrifying.
It is.
Right.
And even in a good year, you might only get one single lower value crop. So the law mathematically recognizes this massive disparity. It calculates that an acre of irrigated wetland is roughly twice as economically productive as an acre of dry land.
Okay. That makes perfect sense.
So if you own just 2.5 acres of wetland, you essentially have the exact same economic baseline as someone struggling with 5 acres of dry land.
It's an equivalency scale.
Exactly. And if you own less than those specific thresholds, the state officially categorizes you as impoverished enough to require a land assignment to survive.
Okay, so the state finds someone who meets this strict math, and they assign them a plot. Now we hit the absolute core of this law. Let's look at Section 3, the Prohibition of Transfer.
This is the shield. Section 3, subsection 1, explicitly states that any land assigned by the government to a landless poor person shall not be transferred.
It totally extinguishes that right of alienation we talked about earlier.
Completely.
And the phrasing in the actual statute is incredibly aggressive. It says the land shall be deemed never to have been transferred.
It's a legal fiction, and it's designed for absolute protection. Subsection 2 elaborates that no landless poor person shall transfer the land, and crucially, no person shall acquire it.
Not by buying it, not by gift, lease, mortgage, nothing.
Nothing. If someone ignores this rule and buys the land anyway, subsection 3 drops the hammer. The transfer is deemed null and void.
It's as if the transaction literally never happened in the space-time continuum of the law.
That's a good way to look at it.
And this is where it gets even more intense. Because the law applies retroactively. The text literally says where before or after the commencement of this act, the land has been assigned.
Yes.
So even if some wealthy landlord bought a plot from a poor farmer in 1970, 7 years before this act was even written, the 1977 act reaches back in time, grabs that transaction, and declares it illegal.
It does.
How can a state justify rewriting history like that? Isn't that a massive overreach?
You'd think so, but the state recognized a horrific historical pattern of systemic exploitation. In the decades after independence, the government was trying to give land to the poor, but wealthy local elites were immediately swooping in.
Just buying it right out from under them.
Exactly. They would use coercion, or they'd exploit a poor farmer's desperate need for fast cash during a medical emergency, and they'd buy the assigned land for absolute pennies.
So the poor person is right back to being landless.
Right back where they started. And the wealthy elite just increased their holdings at the state's expense. The legislature realized that if they didn't make the 1977 law retroactive, they would just be legitimizing decades of theft. They had to reset the board.
But a retroactive law that absolute is going to create immense collateral damage.
Definitely.
Let's imagine a scenario here. A poor, landless farmer scrimps and saves every single rupee for 20 years. In 1975, he buys a small plot of land from other poor farmer who happens to be an original assignee.
Okay.
He obviously doesn't know about the upcoming 1977 law. He pays a perfectly fair market price. He builds a house. He farms the land. Does the government just show up in 1978 and evict him, throwing him into total destitution?
That is exactly the kind of injustice the drafters had to anticipate. They had to balance the need to punish predatory landlords with the absolute need to protect innocent people.
Right.
Which brings us to the crucial exception carved out in Section 3, subsection 5.
Let me read this part because the conditions are super specific. It says, nothing in this section shall apply to an assigned land which was purchased by a landless poor person in good faith and for valuable consideration for the original assignee prior to the commencement of this act.
Notice the immense burden of proof required to trigger that exception. First, the buyer cannot be a wealthy landlord. They must independently qualify as a landless poor person themselves.
Okay.
Second, they must have bought it in good faith, meaning no fraud, no coercion, no exploiting the seller's misery.
Right.
Third, they had to pay valuable consideration. That means a fair market rate price, not just a few rupees to make it look legal.
Got it.
Fourth, the transaction absolutely had to happen prior to 1977. And fifth, they must physically be in possession of the land, actually cultivating it, when the act commenced.
So the state is basically saying,
Yeah.
look, we are hunting the predators who stole this land. But if two poor people engaged in a fair, honest transaction before we formalize the rules, we aren't going to punish the innocent buyer.
Exactly. It creates a safe harbor for historical, equitable transactions while still ruthlessly targeting the exploitative ones.
That's a really elegant solution. Now, there's another major structural exception in the law, and it deals with a massive real-world problem.
Credit.
Yes, credit. If the law says you absolutely cannot mortgage assigned land because a mortgage is a form of transfer, how does a farmer survive?
They can't.
Let's say an assignee needs 50,000 rupees to buy a solar water pump. Normally, you go to a bank, you offer your land title as collateral, and you get a loan. If the 1977 Act bans mortgages, isn't the state essentially cutting these farmers off from the entire modern financial system?
That's the exact trap the law seeks to avoid.
Because then they just go to local loan sharks, right?
Exactly.
Yeah.
Credit is the oxygen of agriculture. Without credit, you can't buy hybrid seeds, you can't buy fertilizers, and you definitely cannot survive a drought. If the state locked the land up completely, it would be a death sentence for the farmer's productivity.
So how do they fix it?
Section 6 and its corresponding explanations carve out a highly specific lifeline for institutional credit.
So they do allow mortgages, but only to specific entities.
Correct. The Act exempts mortgages made in favor of the central or state government or any local authority. It exempts cooperative societies registered under the state's cooperative laws. And crucially, it exempts scheduled banks.
Like the State Bank of India.
Yes, the State Bank of India, the Reserve Bank, agricultural development banks.
Why these specific institutions? Why not private lenders?
Because these are highly regulated, state-monitored financial institutions, they operate on fixed legal interest rates. They do not employ thugs to break your legs if you miss a payment.
That's a plus.
It's a huge plus. If a farmer mortgages their assigned land to the State Bank of India and they default on the loan, the bank has the legal right to recover the dues. But the process is totally institutionalized.
The land doesn't fall into the hands of some predatory local baron.
Right. A baron who charges 60% annual interest. The land remains within a protected, regulated framework. The state is allowing the land to act as financial leverage, but only in safe, controlled environments.
All right, so we have the absolute prohibition, we have the exemption for the historical good faith buyer, and we have the exemption for regulated bank loans.
Those are the boundaries.
But a law is basically just a suggestion if there is no enforcement. Let's look at the teeth of the 1977 Act. What happens if a wealthy developer decides to just ignore Section 3, bribes a vulnerable assignee with a huge lump sum of cash, and illegally takes over the assigned land?
The enforcement mechanisms in Sections 4 and 7 are draconian by design. The power is vested directly in the district collector or a delegated officer like a Mandal revenue officer.
Right.
If the collector discovers that a transfer has occurred in violation of the Act, they don't have to file a massive lawsuit in a civil court and wait 10 years for a verdict. They have the statutory power to issue a direct order and physically take possession of the land.
Wait, they just show up and evict the buyer?
Yes, after serving a formal notice. But eviction is just the beginning. Section 4 explicitly states that any crop or produce raised on that land by the illegal buyer is liable to absolute forfeiture.
So if the developer planted 20 acres of high-value cash crops, the government just seizes the entire harvest.
Yes, and it applies to physical structures, too.
Wait, really?
Oh, yeah. If the developer built a luxury farmhouse or a warehouse or an expensive irrigation facility on that illegally acquired land, that building is forfeited to the state. The collector adjudges the forfeiture and disposes of the property. The financial ruin for the illegal buyer is total.
That is wild. And beyond the financial ruin, there are actual criminal penalties, right? The notes mention Section 7 outlines the punishments.
I'll quote it. Whoever acquires any assigned land in contravention of the provisions shall be punished with imprisonment which may extend to 6 months, or with fine which may extend to 2,000 rupees, or with both.
So actual jail time.
Yes. It elevates the act from a mere civil property dispute to a literal criminal offense against the state. And if the illegal occupant tries to barricade the gates and physically resist the collector's officers, Section 7.2 adds another layer of punishment.
Another 6 months.
Up to 6 months in jail just for impeding the state machinery.
The state is clearly not messing around here. But they don't just rely on punishing the crime after it happens. They've actually engineered this brilliant bottleneck to stop the crime before it can even be formalized.
The registration block.
Yes. This brings us back to our earlier discussion about the Registration Act. Let's look at Section 5 of the 1977 Act.
This is a masterstroke of administrative preemption. Section 5 essentially weaponizes the registration offices. It mandates that the district collector must compile a comprehensive, highly accurate list of all assigned lands in the district.
And then they give that list to the local registering officers.
Exactly. And the Act dictates that, notwithstanding anything in the Central Registration Act of 1908, the local registering officer is strictly prohibited from accepting any document related to the transfer of lands on that list.
So picture this. The wealthy developer and the coerced farmer walk into the registrar's office. They have a perfectly drafted sale deed. They paid the stamp duty in full. They slide the papers across the desk.
Right.
The officer looks at the survey number, checks the collector's list, sees it's assigned land, and just refuses to stamp it. The transaction is structurally aborted.
Exactly. The formal legal alienation can literally never occur. And to make sure the officers don't succumb to bribery, the Act includes a terrifying provision for the bureaucrats themselves.
Oh, I saw this. Subsection 2A of Section 7.
Yes. It states that any officer who intentionally violates this rule and registers an assigned land faces up to 6 months of simple imprisonment.
They threaten their own guys with jail.
The state holds its own machinery criminally liable to protect the integrity of the assignment.
So let's trace the causal chain here. The law says you can't transfer the land. The registrar blocks the paperwork. If you do it secretly anyway, the collector evicts you, seizes your crops, confiscates your buildings, and throws you in jail.
That's the sequence.
But that raises a massive logistical question. The illegal buyer is gone. The land is sitting empty. What actually happens to the physical dirt? The government doesn't just want a vacant lot. This brings us to a really dramatic concept in property law: resumption.
Resumption is the ultimate reversal. It is the legal process by which the sovereign state reasserts its absolute ownership over a piece of land, effectively canceling the rights of whoever was holding it.
And the government can't just do this on a whim, right? The constitutional foundation for this is immense. We're looking at Article 31A of the Constitution of India.
Article 31A is the constitutional engine for all agrarian reform in India. It shields laws that provide for the state acquisition of estates from being challenged on the grounds that they violate fundamental rights.
It basically says the public good matters more.
Exactly. When the state acts to dismantle deep-rooted agricultural inequality, the individual's right to property must yield to the greater public good.
So what pulls the trigger on this massive constitutional weapon? We know that illegally selling an assigned land is one trigger. The collector evicts the buyer and resumes the land. What else?
Non-compliance with the core conditions of the assignment is a major trigger. Say the state gives a landless poor person 3 acres specifically for cultivating food crops.
Okay.
And a year later, that person strips all the topsoil and turns it into a commercial brick-making kiln without any authorization. They have violated the fundamental purpose of the grant. So the state can resume the land.
And there's also the broader concept of public interest, right?
Yes. The state always retains the power of eminent domain. Even if a farmer is perfectly following the rules, cultivating their land diligently, the state might discover that the only viable path for a crucial new national highway or a massive irrigation canal that will water 10,000 other farms runs directly through that specific plot.
Oh, man, so they just take it.
In that scenario, the state can resume the assigned land for the broader public interest, though they are usually obligated to provide alternative land or compensation.
Let's look at the exact operational flowchart for resumption under the 1977 Act. We are looking at Section 41B. The collector has resumed the land from an illegal buyer. The state now holds the title again. What are their options?
The primary directive of the law is restorative. The state wants the land to serve its original intended purpose. So under Section 41B, the first option is to restore the assigned land back to the original assignee.
But wait, the original assignee is the one who broke the law and illegally sold it to the developer in the first place. Why does the state give it back to them?
Because the law operates on the presumption that the landless poor person was likely coerced or deceived or forced by crushing economic desperation into making that illegal sale.
They see them as the victim.
Exactly. The state treats them as a victim of the system, not a mastermind criminal. However, there is a very strict limit to this grace. The Act explicitly says the restoration happens for one time.
You get 1 second chance.
Exactly, one strike. The state restores the land to you and essentially says, do not do this again. If the assignee turns around 3 years later and illegally sells the land a second time, the proviso dictates that the land shall be permanently resumed.
They lose it forever.
The original assignee loses all rights forever.
What happens to the land then?
Then the state moves to the next option under Section 4B3. They assign it to another eligible landless poor person in the same village.
Keep it in the community.
Exactly. The land stays within the demographic it was designed to help. It just changes hands to someone who will obey the tenure rules.
There is also a provision here for the good faith purchaser we talked about earlier. If the state resumes the land, but discovers the current occupant is actually just another poor farmer who bought it honestly but illegally before a certain cutoff date, the Act mentions December 31st, 2017.
Right.
The government can choose to simply reassign the land officially to that purchaser, basically regularizing their status.
It's a very pragmatic approach to avoid creating new landless people while still trying to enforce the law.
And finally, what if there are no eligible landless poor people left in the village? Like, what if everyone who qualifies already has an assignment?
Then the Act allows the resumed land to be utilized for a public purpose. And the explanation section is very specific about what this means. It can be used for building housing for weaker sections of society, or public utilities like hospitals or schools.
Infrastructure stuff.
Yeah, massive infrastructure development, the promotion of industries, or even tourism projects. The logic is that if the land cannot serve individual agrarian welfare, its value must be harnessed for the collective economic and social upliftment of the region.
You know, looking at all of this, the strict assignments, the bans on transfers, the constant threat of the government resuming the land if you violate a condition, I have to ask a deeply philosophical question about the nature of property. If the state hands you a piece of land, but dictates that you cannot sell it, you cannot freely mortgage it, you cannot change its use, and they can seize it back if they need it for a highway. Do these marginalized farmers ever actually own the land? Or are they just perpetual tenants of the state, living under a legal microscope?
That is the defining tension of agrarian reform jurisprudence. It's a great question. If you define ownership strictly through the lens of pure, unregulated capitalism, where ownership means the absolute unfettered right to alienate, destroy, or commodify the asset, then no, they do not possess absolute ownership.
They just have a license to use it.
They possess restricted tenure. But from the perspective of constitutional social justice, this restriction is not a deprivation. It is a vital life support system.
And the Supreme Court has weighed in heavily on this philosophical collision. We have to look at the jurisprudence here. Let's start with a massive case from 1952. The state of Bihar versus Maharaja Raja Sirkameshwar Singh of Darbhanga.
This is one of the most critical foundational cases in Indian constitutional history. It dealt with the abolition of the zamindari system.
We really need to explain zamindari for a moment so the listener understands the stakes. Under the British, the colonial government didn't want the logistical nightmare of collecting taxes from millions of individual peasant farmers.
Too much paperwork.
Way too much. So they essentially created local feudal lords, the zamindars. The zamindar was given massive tracts of land and owed the British a fixed annual revenue. But the zamindar could extract whatever he wanted from the actual peasant farmers working the land.
It was a system designed for brutal, unchecked exploitation.
Exactly. And when independent India was born, the very first major legal objective was to dismantle this system and take the land back from the zamindars to redistribute it. The zamindars, like the Maharaja of Darbhanga, obviously fought back furiously.
They didn't want to lose their empires.
Right. They went to the Supreme Court arguing that the state seizing their estates violated their fundamental right to property.
And what did the Supreme Court say?
Well, the court established this bedrock principle, that the power of the state to acquire private property for a public purpose specifically, the massive public welfare purpose of agrarian reform, and dismantling a deeply inequitable feudal structure that overrides the absolute proprietary rights of the individual.
The public good trumps private commodification.
Exactly. And this logic trickles down directly to assigned lands today. We see it in Narayan Rao versus State of Andhra Pradesh from 1967.
The High Court in that case was dealing specifically with the restrictions on assigned lands, and the court unequivocally upheld the state's power. They ruled that lands assigned to the weaker sections carry an inherent condition of non-alienation.
You can't separate the two.
Right. Any transfer breaches that condition and makes the land immediately liable for resumption.
So the judiciary views the inability to sell the land not as a lack of ownership, but as an essential protective barrier.
Yes. The courts and the legislature understand a really grim economic reality. In a highly unequal society, a completely free market in land is dangerous for the poor.
Because they'll just lose it again.
Exactly. If a destitute farmer is given absolute, unrestricted ownership of their land, the very next time a medical emergency hits, or a daughter needs to be married, or a drought destroys the crop, they will be forced by market pressures to sell that land to a wealthy neighbor.
They become landless immediately.
The restriction on alienation is basically the state chaining the farmer to the land for their own long-term survival. It protects them from the immediate, desperate impulses of a free market.
Okay, we have covered the mechanisms of poverty and state-assigned lands. But there is another dimension to land alienation. There is a demographic whose relationship with the earth predates the modern Indian state, predates the British Empire, and operates on an entirely different philosophical frequency.
This is a profound shift in the topic.
It really is. To understand the absolute deepest, most heavily fortified and fiercely contested legal protections against land alienation, we have to travel into the scheduled areas. This is where history, blood, and the law all collide.
We are stepping into an incredibly sensitive and historically traumatic area of jurisprudence here, tribal land alienation. To understand the laws today, you have to understand the worldview that existed before the laws were even written.
Let's paint that picture for the listener. Before the colonial era, tribal communities, the Adivasis, generally did not view land through the lens of individual commodified title deeds.
No, not at all.
The sources show they operated heavily on systems of communal or clan ownership. An individual tribal farmer considered themselves a custodian. They had the right to cultivate a specific plot, and their children would cultivate it after them, but the land ultimately belonged to the community, the ancestors, and the deities.
The relationship was entirely symbiotic. The forest and the soil were not financial assets to be leveraged. They were the source of physical survival, spiritual identity, and social cohesion.
Right.
The idea of permanently alienating a piece of the forest to an outsider in exchange for currency was conceptually alien to them.
But then the British East India Company, and later the British Crown, arrived with an entirely different operating system. They looked at the vast forests and saw timber, minerals, and massive potential for land revenue.
And they imposed this rigid, totally alien administrative architecture. We talked about the zamindari system earlier. They also introduced the Ryotwari system, where individual cultivators were directly assessed for cash taxes, and the Mahalwari system, assessing entire village estates.
So suddenly, the tribal cultivator, who had lived for centuries by customary law, was told they needed a piece of paper to prove they owned the land they were standing on.
And they had to pay a cash tax they couldn't possibly afford to a government they didn't even recognize.
The results were catastrophic. Outside moneylenders, traders, and revenue officials just flooded into the tribal areas. Because the tribals didn't understand the new, complex legal and financial systems, they were systematically defrauded.
Trapped in debt.
Yes. Trapped in debt, their lands were confiscated for unpaid taxes, and the original custodians of the forest were reduced to impoverished day laborers working on their own ancestral soil for outside masters.
And this is the crucial historical context, this rapid, violent dispossession did not happen silently. The modern protective laws we're about to discuss were not handed down benevolently. They were forced into existence by massive, bloody resistance.
The history of tribal land law is literally written in the smoke and fire of uprisings. Our sources list them, and the scale is staggering. The Chonagpur Tribal Revolt of 1807, the Coal Rebellion of 1831, where thousands of tribals rose up against the influx of outside land grabbers.
And the Santhal Rebellion?
Right, the massive Santhal Rebellion of 1855, where tens of thousands of Santhals mobilized against the Zamindars and the British police. The Rampa Rebellion in 1879 and the Godavari Agency, the Gone Revolt of 1940. The list spans over a century.
These were not minor local riots. These were sustained, armed, existential wars for the soil. They severely threatened the stability and profitability of the British administration.
So the British had to react.
Eventually, the colonial government realized that pure military suppression was unsustainable. Out of sheer administrative self-preservation, they realized they had to legally quarantine these areas. They had to create special zones where the aggressive outside market forces were legally barred from entering.
Which led to those early laws.
Exactly. Early, specialized legislation like the Chotanagpur Tenancy Act of 1908, which strictly prohibited the transfer of tribal land to non-tribals.
And when India gained independence, the architects of the Constitution looked at this exact history of exploitation and rebellion, and they wove those protections directly into the DNA of the new republic.
The legal armor protecting tribal lands today is immense.
Let's walk through the layers. First, we have Article 244 of the Constitution.
Article 244 is the foundational constitutional mandate. It recognizes that certain regions, due to their distinct tribal populations, unique cultures, and historical vulnerability, just cannot be governed by the standard, one-size-fits-all administrative machinery.
It empowers the president to officially declare specific territories as scheduled areas.
Right. And once an area is declared a scheduled area, the fifth schedule of the Constitution kicks in.
And what does the fifth schedule actually do?
It creates a specialized parallel governance structure. It dramatically shifts power. Crucially, it mandates the creation of tribal advisory councils. These councils are heavily composed of tribal representatives, and they must be consulted on any matters pertaining to the welfare and advancement of the scheduled tribes in that state.
And the governor gets a lot of power too, right?
Extraordinary constitutional powers. The governor can literally suspend or modify any act of parliament or the state legislature if they determine it would be harmful to the scheduled area.
That is an incredible amount of constitutional power designed purely for protection. But the law evolved even further to decentralize that power. In 1996, we get a revolutionary piece of legislation, PISA, the Panchayat's Extension to Scheduled Areas Act.
PISA represents a total paradigm shift from state-led protection to community-led autonomy. It officially recognizes the traditional, customary modes of dispute resolution and self-governance.
At the heart of PISA is the Gram Sabha, right?
Yes, the Gram Sabha, the assembly of all adult members of the village.
How does PISA change the dynamic of land alienation on the ground?
It flips the power structure upside down. Before PISA, a state bureaucrat in a distant capital city could decide to acquire tribal land for a mining project. Under PISA, the Gram Sabha is endowed with immense authority over land, water, and forest resources.
So they have to be consulted.
More than consulted. The law mandates that the government must consult and often obtain the consent of the Gram Sabha before acquiring land in the scheduled area for any developmental project or before resettling affected persons. The village community basically gets a legal veto.
And adding to this armor is the Forest Rights Act of 2006.
The Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act. For generations, forest departments treated tribal communities as illegal encroachers in forests they had inhabited for millennia.
Which is insane.
Totally. The 2006 Act legally recognizes and vests forest rights, the right to inhabit, the right to cultivate, and the right to collect minor forest produce back into the hands of the traditional forest dwellers. It repairs a massive historical injustice.
So, we have the president declaring scheduled areas under Article 244. We have the governor's sweeping powers under the 5th Schedule. We have the veto power of the Gram Sabhas under PISA. We have the historical restitution of the Forest Rights Act. And we have specific state laws, like the Andhra Pradesh Scheduled Areas Land Transfer Regulation of 1959, which explicitly bans transferring tribal land to non-tribals.
That is a fortress of legal protection.
It is, and yet, despite all of this, the sources highlight a really dark, ongoing reality. Hundreds of thousands of acres of tribal land continue to be alienated today.
Yeah, the laws are struggling to hold the line.
How? If the law is this strict, how does the land keep slipping away?
Because the economic value of the minerals beneath that land and the timber upon it is astronomical. The pressure from outside capital is relentless. When the front door of legal transfer is barricaded by the Constitution, exploitation just finds the cracks in the walls. Our sources detail the deeply insidious mechanisms used to circumvent the law.
Let's break down the mechanics of how this theft actually happens on the ground. The first method is simply the brazen illegal sale, facilitated by corruption. The notes cite a specific example from the Chambal region where 190 acres of highly cultivable tribal land were acquired by powerful, non-tribal local families.
In cases like this, the law is simply ignored. Powerful families use their political connections and sheer local intimidation to take possession of the land. The tribal owners are too marginalized and the local police too compromised to stop it.
The second method is quieter, but far more devastating. The manipulation of land records.
This involves the weaponization of the bureaucracy itself. The local revenue official, the patwari, controls the physical ledgers. Through bribery, a non-tribal entity pays the patwari to systematically alter the records.
So they just change the books.
Exactly. They might change the classification of the land, erase the tribal owner's name, and insert a fake non-tribal name over several years. By the time the tribal farmer realizes what has happened, the official state records those very ledgers we discussed earlier say they no longer own their ancestral home.
And closely related to that is the tactic of fake demarcation. How does this scam work?
Imagine a tribal farmer is allotted a specific plot of land. The patwari brings them out to the field, points to a fertile patch, and says, "This is your land."
Yeah.
The farmer spends months clearing it, tilling it, and planting a crop. Right before the harvest, the patwari returns with a wealthy non-tribal farmer. The patwari pulls out the survey map and says, "Oh, there was a mistake in the demarcation. Your land is actually over there on that rocky, uncultivable hillside."
Oh my God.
Yeah. This fertile land, with the crops you just grew, belongs to this gentleman. The tribal farmer loses their labor, their harvest, and their land in one stroke of bureaucratic fraud.
It's terrifying because the fraudster is the very official supposed to protect them. But the most widespread systemic method of alienation is financial. It is the debt trap.
This is the most tragic mechanism because it uses the farmer's own desperation against them. Tribal agriculture is often rain-fed and highly vulnerable. If a farmer faces a drought or a severe medical emergency, they cannot go to a formal bank because banks require complex documentation they often don't have.
So they turn to the local, informal moneylender.
Exactly.
Walk me through the math of how a small loan turns into the loss of a 5-acre farm.
Let's say the farmer borrows 5,000 rupees to buy seeds. The moneylender, operating entirely outside the law, charges an exorbitant interest rate, sometimes 5% or 10% per month.
Per month, that is 60 to 120% annually.
Yes. The farmer pledges their land as informal collateral. A bad monsoon hits, and the crop fails. The farmer cannot pay the principal or the massive interest. The interest compounds. Within 2 years, that 5,000 rupee loan has ballooned into a 50,000 rupee unpayable debt.
And the moneylender demands the land and settlement.
Right. Even though transferring tribal land to a non-tribal moneylender is explicitly illegal, the moneylender simply takes physical possession of the land. The farmer is too poor and too terrified to initiate a decade-long legal battle in civil court to get it back. The alienation is complete.
And finally, there is the alienation conducted by the state itself, institutional alienation.
Yes, the scheduled areas are often the most resource-rich regions in the country. They hold vast reserves of coal, bauxite, and iron ore. They are the prime locations for massive hydroelectric dams.
So the state uses eminent domain.
The state frequently uses its power of eminent domain to acquire vast tracts of tribal land for these public-purpose mega projects. While the law mandates compensation and resettlement, the reality is often grim.
Because money doesn't replace a culture.
Exactly. The financial compensation is quickly squandered because the community is unaccustomed to cash economies, and the resettlement colonies often lack the profound cultural and ecological connections of their ancestral forests. The community is fractured and impoverished.
It is a relentless, multi-front siege. The moneylender, the corrupt official, the mining corporation. But the judiciary has occasionally stepped in with massive tectonic rulings to reinforce the armor and fight back against these forces. We have to discuss the Samatha case from 1997.
Samatha versus State of Andhra Pradesh is arguably the most consequential judgment in the history of tribal land rights. The context is crucial here.
Set the scene for us.
The state government of Andhra Pradesh was leasing out massive tracts of land in the scheduled areas to private, non-tribal, multinational mining companies to extract bauxite. A non-governmental organization, Samatha, challenged this, arguing that leasing tribal land to a private corporation violated the Fifth Schedule and the state's own protective regulations.
And the Supreme Court delivered a bombshell ruling.
They really did. The Supreme Court interpreted the word person in the regulation prohibiting the transfer of land to a non-tribal person to include the state government itself, as well as private corporations.
Wait, so the state is a person?
In this context, yes. The court held that the government cannot act as a middleman to circumvent the Constitution. They ruled that tribal lands, forest lands, and government lands in scheduled areas cannot be leased to private mining companies. Only the State Mineral Development Corporation or a tribal cooperative could undertake mining.
It effectively slammed the door on private corporate exploitation of tribal lands in that state.
Slammed it shut.
Speaking of slamming the door on mining, we have an even more recent, incredibly dramatic David and Goliath story. The Niyamgiri Suraksha Samiti case from 2013.
This case brought the power of PISA and the Forest Rights Act into razor-sharp focus. A massive global mining conglomerate, Vedanta, wanted to mine bauxite in the Niyamgiri Hills in Odisha.
But the hills aren't just hills, right?
Right. The Niyamgiri Hills are not just land. They are the sacred living deity of the Dongria Khand, a particularly vulnerable tribal group. The state government had given the clearances, the corporation was ready to move in, but the tribals resisted.
How did the Supreme Court handle the collision between a multi-billion-dollar industrial project and a tribe's sacred mountain?
The Supreme Court did something unprecedented. They did not just rule from the bench in Delhi. They invoked the Gram Sabha provisions of PISA and the Forest Rights Act. The court ordered that the decision of whether the mining project would violate the religious and cultural rights of the Dongria Khand had to be made by the tribal communities themselves.
Wow.
They mandated that Gram Sabhas in the affected villages must hold formal votes.
The ultimate democratic veto.
Exactly. The government officials had to actually travel up the mountain, hold the assemblies, and ask the community. And village after village, the Gram Sabhas unanimously voted no. They rejected the mine.
And the Supreme Court upheld it.
And the Supreme Court upheld their decision. The multi-billion-dollar project was canceled. The Niyamgiri case proved that the legal armor, when properly enforced by the highest court, can actually withstand the immense pressure of global capital.
While we are discussing landmark jurisprudence, there's one more case the sources highlight that brings a crucial internal dimension to this discussion: the Madhu Kishwar case. Because the fight isn't always just against the outside corporation or the moneylender. Sometimes the fight is for equality within the community itself.
Yes, this is a really important one. This case tackles the intersection of constitutional rights and tribal customary law. Historically, many tribal communities operate on patrilineal customary laws, meaning property, especially land, only passes down through the male heirs.
Leaving the women out entirely.
Tribal women were entirely excluded from inheriting movable property. The rationale within the custom was that women would marry outside the clan, and if they inherited land, the land would pass out of the clan's control, leading to alienation.
But that leaves tribal women incredibly vulnerable, especially widows or unmarried daughters.
Precisely. Madhu Kishwar, an activist, filed a petition in the Supreme Court challenging sections of the Chorkanagpur Tenancy Act that restricted succession to male heirs. The challenge was profound. Does the constitutional guarantee of gender equality override the constitutional mandate to protect distinct tribal cultural practices?
It's a massive legal tightrope.
Yeah.
How did the court rule?
The Supreme Court walked that tightrope very carefully. They didn't outright strike down the customary law, fearing it would cause absolute chaos in tribal land holdings.
Right.
However, they ruled that the exclusive right of male succession must be read down. They guaranteed the right of dependent tribal women, widows, and unmarried daughters to hold and enjoy the land during their lifetime to secure their livelihood. It was a vital step in ensuring that the legal fortress protecting the tribal community also protects the most vulnerable individuals within that community.
Okay, let's take a deep breath. We have journeyed through the massive, complex architecture of land alienation. We have seen the strict prohibitions of the Assigned Lands Act. We have traced the blood-soaked history and the constitutional fortresses of the scheduled areas. We understand how the laws are broken through debt, fraud, and corruption.
It's a lot to take in.
Now imagine you are that marginalized farmer whose assigned land was stolen by a developer. Or you're a tribal woman fighting a fraudulent patwari. The laws exist to protect you. But how do you actually enforce them?
That's the million-dollar question.
Because if you take your case to a standard civil court, you are stepping into a nightmare. Dragging a destitute farmer through a 20-year civil litigation process, battling a wealthy corporation with infinite legal funds, that is not justice. It is attrition.
It's just bleeding them dry.
Exactly. The legal system realized it was failing at the ground level, and it had to evolve. This brings us to the final arena of our deep dive, the battlegrounds of special tribunals.
When the traditional legal machinery proves too rigid, too slow, and too expensive to handle the volatile, urgent realities of land disputes, the state creates specialized tactical forums. We are looking at the rise of special tribunals.
Our sources list a whole array of these specialized bodies. We have land dispute tribunals, LDTs, set up under specific state laws like the Bihar Land Dispute Resolution Act.
Right.
We have the National Green Tribunal, the NGT, handling the massive environmental consequences of land use. We have special land acquisition courts dealing with the fallout of the state, claiming eminent domain under the 2013 LRR Act. And we have rare area tribunals explicitly designed to untangle real estate and builder disputes.
The proliferation of these bodies is basically a direct admission by the state that the traditional civil courts are in crisis. An ordinary title dispute in a civil court can literally span generations.
The grandson finishes the lawsuit the grandfather started.
Exactly. By the time a verdict is reached, the original plaintiff and defendant might be dead. Special tribunals are engineered for specialized expediency.
Let's use an analogy to understand the mechanical difference between a regular court and a tribunal. Think of the regular civil court system like a massive, heavy freight train running on a highly specific, fixed track.
I like this analogy.
That track is the Code of Civil Procedure, the CPC, and the Indian Evidence Act. Every single movement, every piece of paper, every spoken word must perfectly align with the track. If a tree falls on the track, a procedural error, a missing stamp, a typo in a filing, the entire train stops completely until a highly complex formal protocol clears the track.
It's powerful, but incredibly slow.
Yes, and totally inflexible. In contrast, a special tribunal is like an off-road Jeep.
That is an excellent functional comparison. The defining characteristic of the Jeep is its procedural flexibility. The statutes creating these tribunals usually explicitly state that they are not strictly bound by the rigid tracks of the Code of Civil Procedure or the strict evidentiary rules of the Evidence Act.
So what steers the Jeep, if not the tracks?
They are steered by the principles of natural justice. This essentially means fairness, equity, and common sense.
So they can just bypass the fallen tree.
Exactly. The tribunal judge can steer around it. They can look past a minor formatting error on a petition. They can allow a farmer to speak directly without requiring a lawyer to file a triple-stamped affidavit. The goal is to get to the truth of the dispute and deliver a practical resolution quickly, often within a statutorily mandated time frame, like 3 to 6 months.
And it is not just about the vehicle. It is about who is actually driving it. In a civil court, you have a generalist judge. That judge might hear a brutal murder trial on Monday, a complex corporate divorce on Tuesday, and then try to understand a century-old tribal land survey dispute on Wednesday.
Which is incredibly difficult.
Right, but tribunals offer subject expertise.
This is a massive advantage. Special tribunals are typically composed of members who possess deep, specialized knowledge of the exact subject matter. A land dispute tribunal won't just have a legal scholar. It will often include a former senior revenue officer who has spent 30 years physically walking the fields, reading the Patwari ledgers, and understanding the nuances of local land tenure.
So when a farmer explains how a boundary marker was fraudulently moved,
The tribunal member inherently understands the mechanics of the fraud in a way a generalist judge just might not.
the benefits are obvious. The procedures are simpler, which drastically reduces the cost of hiring specialized lawyers, making justice accessible to the poor. The tribunals are often localized at the district level, so the farmer doesn't have to travel hundreds of miles to a high court in the capital.
However, we must view the system with absolute objectivity. While the theory of the off-road Jeep is excellent, the reality of these battlegrounds is deeply flawed. The sources outline several critical systemic challenges.
The first is the sheer volume, pendency, and vacancies.
The state created these tribunals to bypass the backlog of the civil courts, but they have simply created new backlogs. Governments frequently pass laws creating a tribunal, but then fail to actually appoint the judges or provide the administrative staff.
So you have tribunals with thousands of cases piling up, but the chairs are empty.
The Jeep has no driver.
There is also the issue of inconsistency. Because they aren't bound by the strict tracks of the CPC, different tribunals, or even different members within the same tribunal, might apply natural justice in vastly different ways, leading to unpredictable rulings.
That's a huge problem for legal precedent.
But I want to push back on the very architecture of these tribunals because the sources raise a massive red flag: executive interference.
Yeah, this is the big one.
Let's think about this logically. A farmer is fighting the government because the government is trying to resume their assigned land to build a highway. The farmer goes to the special tribunal. But the government is the entity that created the tribunal.
Right.
The government pays the tribunal members' salaries. The government appoints the members, and often the members are former government bureaucrats themselves. How is that not a massive systemic conflict of interest? How can a citizen expect an impartial ruling when the judge literally works for the entity trying to take their land?
You have hit upon the central, enduring constitutional crisis of the tribunal system in India. The fear that tribunals are simply an extension of the executive branch, a way for the government to bypass the independent judiciary and rule in its own favor, has been the subject of furious legal battles for decades. If the executive controls the appointment and the funding, the independence of the tribunal is deeply compromised.
So, what is the safety valve? How does a marginalized farmer protect themselves from a tribunal that is clearly biased by the state?
The safety valve is the unalterable architecture of the Constitution itself, specifically the power of judicial review. To understand how this works, we must look at the definitive Supreme Court ruling on this exact tension, the L. Chandra Kumar case of 1997.
Walk us through the mechanics of that ruling.
In L. Chandra Kumar, the Supreme Court had to decide whether the government could create tribunals that completely excluded the jurisdiction of the traditional high courts. The government wanted the tribunals to be the final word.
And the Supreme Court said absolutely not.
They pulled rank. They asserted the basic structure of the Constitution. The court ruled that while tribunals are competent to hear cases, act as courts of first instance, and deliver rapid judgments, they can never fully escape the supervisory jurisdiction of the higher constitutional courts.
So the high courts always have the last say.
Exactly. The high courts possess the power of judicial review under Article 226, and the Supreme Court possesses it under Article 32.
Meaning the Jeep can drive off-road, but it can never drop off the constitutional radar screen.
Precisely. If a special tribunal acts with clear bias, if it blatantly ignores the law, or if a government-appointed member clearly rules in favor of the state despite the evidence, the aggrieved citizen always retains the fundamental right to appeal to the High Court.
That's a huge relief.
The High Court has the power to look down at the tribunal, review the decision, and strike it down if it violates constitutional fairness. The tribunals provide the speed, but the high courts ensure the constitutional checks and balances remain permanently intact.
What an incredible journey. We have covered a staggering amount of legal, historical, and human territory today. Let's zoom out and map exactly what we have unpacked.
Sounds good.
We started with the basic physics of alienation. Understanding that moving property isn't a handshake, It requires the rigid, immutable ledgers of the Registration Act of 1908 to prevent generational chaos, a system that's now being revolutionized by digital passbooks in states like Telangana.
We then explored how the state aggressively intervenes in the free market using the 1977 Assigned Lands Act. We examined the agrarian economics of wet versus dry land and how the state imposes an ironclad retroactive shield to prevent the poor from being stripped of their assignments, backing it up with the dramatic power to resume the land, forfeit crops, and imprison violators.
From there, we plunged into the deep, ancient history of tribal lands. We saw how the brutal economic extraction of the Zamindari and Riyawari systems ignited massive blood-soaked rebellions across a century. We examined the incredible constitutional armor forged from those uprisings, the Fifth Schedule, PISA, the Forest Rights Act, and the tragic, insidious ways those laws are still bypassed today through debt traps and bureaucratic fraud, leading to epic legal showdowns like the Samatha and Niyamgiri cases.
And finally, we analyzed the modern arenas of dispute, the special tribunals. We looked at how they trade the rigid, slow procedures of civil courts for the speed and subject expertise of natural justice, while relying on the ultimate safety net of high court judicial review to protect citizens from executive overreach.
So if you are studying Unit V of the Osmania University syllabus, I hope you see now that you are not just memorizing dry statutes and section numbers to pass an exam.
Yeah.
You are studying the actual living blueprint of socioeconomic justice. You are learning how a society uses the machinery of the law to try and protect the most vulnerable people on Earth from being swallowed whole by the powerful.
And as we close this deep dive, examining all these complex legal shields and historical battles raises one final overarching question to ponder. We are living in an era where India is racing at breakneck speed towards becoming a dominant global economic superpower. To fuel that development, to build the megacities, the highways, and the industrial corridors, there is a massive, relentless push to turn all land into a liquid, tradable, frictionless financial asset.
But as we have seen today for millions of marginalized farmers and tribal communities, land is absolutely not a financial asset. It is not liquid, it is their only social safety net, it is their ancestral continuity, and it is their cultural identity.
Exactly. Can a modern, rapidly growing legal system successfully manage this contradiction? Can it simultaneously treat land as a frictionless commodity for the wealthy to trade, while fiercely protecting it as an inalienable human right for the poor? Or are these two fundamental legal philosophies on a collision course that the courts will eventually be unable to manage?
A massive collision of philosophies. It brings us right back to our starting point. We crave simplicity. We want transactions to be as easy as buying a cup of coffee. But when you are treating the earth beneath someone's feet, the transaction is never simple. It is history, it is blood, it is survival. And the dense, complex, muddy waters of the law are the only things trying to hold it all together. Thank you for joining us on this deep dive. Keep questioning the systems, the ledgers, and the laws around you, and we will see you next time.